Hello, YouTube. I'm Vince White. I'm an employment attorney on this channel. We answer publicly posted questions from YouTube users, getting folks the answers they need from an employment attorney. We have a question here from YouTube user Boss W34, who says, in terms of mandatory arbitration, if you have solid facts and strong evidence of a company breaking the law, can they offer a settlement, or can I reject everything and go public with this information? So the answer is it depends on what you agreed to and what jurisdiction you're in. Because in some jurisdictions, or so under some readings of the law, it may or may not be legal to require confidentiality or non-disparagement provisions in an employment agreement. Now, your mandatory arbitration agreement, depending on what it says, may not include any kind of confidentiality or non-disparagement provision. It may just be that your mandatory arbitration provision is just mandating arbitration for you and nothing more. That is actually fairly common. Now, you may also, separate from or even included in your mandatory arbitration agreement, have confidentiality agreements, have mutual non-disparagement agreements, or even just non-disparagement. So the answer to what you're asking is, it depends on what you signed. Check what you signed, or have an attorney check what you signed. But also, when you have a local attorney check what you signed, reviewing it for you, starting a new medicine for the cough. When you have a local attorney check what you signed, have a conversation with them like, hey, under the current law, recent rulings out of maybe federal agencies or maybe some local legislation that came down in your jurisdiction, what is the law? Is this enforceable? And be specific. Is this enforceable given the disclosures I want to make, the things I want to say? And that's going to stink for me, because I want to give you a better answer than that. But for you, that's the process. That's what you got to do to find out what you can say, what you're subject to. If you don't feel confident in reading the agreement, reading everything that you agreed to, all your contractual agreements, and determining what you can and cannot say, then the recourse is hire an attorney to do that. I mean, not my firm. Don't hire our firm to do that. That would be way too expensive. Would not make sense. Hire local counsel to do a good job. It's not rocket science to read the agreement and tell you what you agreed to. Not that you should know how to do it, but for an attorney who's went to school for this stuff and has many repetitions reading these agreements, it's not rocket science, right? Certainly, many people who are not attorneys can do it. Doesn't mean you should or shouldn't be able to do it. I'm just saying many people don't need an attorney. If there's any question, because this is a big determination, then hire an attorney, right? I hope this helps, Boss W34. In terms of your solid facts and strong evidence, that sounds great. When you say the company's breaking the law, one of the big questions is, which law? Does that law give you a private right of action? Is that law going to birth a valuable claim for you? Is this law going to give you tremendous leverage in your litigation? And I hope the answer to that is that yes, it will give you leverage. It does have a private right of action, and it is a big money claim for you. But do make sure that you do that research or speak to an attorney about it before you take any drastic choices or actions, right? I hope this is helpful. If it was, like, subscribe, comment down below. Share our channel so it can grow. Take care, everybody.